In this video, we're going to go over the termination of parental rights laws in Alabama. My name is Sam Bone. I'm a Gadsden, Alabama adoption lawyer. And I'm first going to go through the fact that uh, there's a termination of parental rights, which is where you're just ending the rights of the other parent. And there's another way to do it, which would be a step-parent adoption. The step-parent adoption is much easier to get done than a parent versus parent termination. So if there is a step-parent that is willing to step up and adopt, it's much easier to do than termination of parental rights. So if we have someone willing to step up, reach out to me and we'll get that done. I have other videos that go over step-parent adoptions. But in this video in particular, we're just going over a parent versus parent and termination. So why would you terminate rights if there's not someone to step up and be a step-parent? You might want to prevent the other parent from coming in and out of the child's life. I mean, it's not necessarily healthy to have a parent who goes 2 years not seeing the kid and then shows up to a child's birthday party, or a parent that will do good for 6 months and then go 2.5 years on a drug bender. It's not necessarily healthy for the child to see their parent acting that way, coming in and out of the life. Another one would be to prevent abuse for the child. That anytime the child's been in their care, that the child is in danger. That could be from drugs, abuse. There's all sorts of reasons that would be, but those are some of the reasons why you might get that done. So there's two basic ways to do a termination of parental rights. There's by agreement, or two is contested, which is the other party doesn't agree. Obviously, if you do it by agreement, it's much faster, it's cheaper, it's much more likely to go through and be approved by the court than if it's contested. Again, earlier we talked about how much easier it is if you've got a step-parent adoption versus a contested termination of parental rights. The reason for that would be courts don't want to bastardize a child. They don't want to have the child have only one parent. They prefer to have two. So if you are going to get that done, I'm going to go over the standard for how to do that. The standard to terminate parental rights is in this statute here, 1215-319. A juvenile court may terminate a parent's rights to a child if it finds from clear and convincing evidence that so this is a pretty high burden here, clear and convincing evidence. It's higher than what we'd call a preponderance standard, which is just more likely than not, which is what you have in just regular old civil cases. But it's lower than beyond a reasonable doubt that we have in a criminal case. So clear and convincing evidence that the parent is unable or unwilling to discharge his or her responsibilities to and for the child, or that parent's conduct or condition renders that parent unable to properly care for the child, and that conduct or condition is unlikely to change in the foreseeable future. Sounds a lot like some legal jargon. The court clarifies next what that means or what a court is to consider in reading this particular part of the statute. The juvenile court shall consider, among other things, number one, that the parents have abandoned the child. What is the definition of abandonment? There is a rebuttable presumption that the parents are unable or unwilling to act as parents if they have abandoned this child for a period of 4 months before filing the petition. So it's 4 months, no contact, no child support, is generally what I will tell people for abandonment. Next, emotional illness, mental illness, or a mental deficiency of the parent, or excessive use of alcohol, controlled substances of a duration or nature as to render the parent unable to care for the needs of the child. Tortured, abused, cruelly beaten, or attempted to torture, cruelly beat, or also done this to a sibling, not necessarily just this particular child. Conviction of and imprisonment for a felony. It's not just enough for a felony, it's got to be imprisonment. Commission of murder or manslaughter, aiding and abetting, or a felony assault to the child or another child of that parent, Here it goes through the definition. Unexplained serious physical injury to the child under circumstances that would indicate the injuries resulted from intentional conduct or willful neglect of that parent. This is DHR. We're not going to go over that here. The parental rights to a sibling of the child have been involuntarily terminated. So this would be a reason why if you are close to getting your rights terminated by DHR or another case, that you may want to voluntarily terminate your rights, because they can use involuntary termination of a sibling against you in the future as grounds for termination of this child. Failure to provide for the material needs or a reasonable portion of support of the child where the parent is able to do so. Back child support is what this is. Or even if there's haven't paid, even if there's not an order to pay child support, there's still a duty of a parent to provide for the needs of the child. Failure to maintain visits. This is DHR. Failure to maintain consistent contact or communication coming in and out of the child's life without consistency. Lack of effort to adjust circumstances to meet the needs of the child. Existence of emotional ties that have developed between the child and his foster parent or parents. And then it goes into length of time with the foster parent, severing the ties of the foster parent, things like that. Okay, and then next, this is the most important part of the law in determining whether to terminate the parent's rights. The juvenile court is required to do a two-pronged test. One, clear and convincing evidence that the child is dependent, which means that there's not a parent willing to take care of the child. And this is the important part. And the court must consider and reject all viable alternatives to a termination of parental rights case. So they have to consider maybe the status quo, that the father is not visiting with the child at all, and the mother perhaps could file something in circuit court or district court to just keep him from having visits without going all the way to the extent of termination. Why would a court say that? Well, 2 or 3 years down the road, the father or mother, whichever one, could get off drugs and could become a good role model for the child. That might be a reason why the court wouldn't want to terminate the viable alternative of what's called the status quo, what's going on now, which may be no visits. So the court has to consider why the status quo of no visits can't just remain in place, and you have to go to the ultimate decision to actually terminate. So again, this is the law on termination of parent versus parent. It's always easier to get a step-parent adoption if you can. If you have any questions about a step-parent adoption or a parent versus parent, reach out to me. We can do it by agreement or contested, either one. Watch my other videos on step-parent adoption. That can get you in the right direction as well.